For 19 years, Margaret was the one in Baton Rouge, driving her mother to every cardiology and rheumatology appointment. She managed 11 different prescriptions. Her sister, Linda, lived a very different life, 1,000 miles away in Phoenix. The scope of that care grew quietly. It meant filling a sprawling pill organizer every Sunday evening and rescheduling her own life because her mother's needs always came first. That routine ended when their mother passed away on a Tuesday morning in October. Linda, whose usual contribution was a few days' visit around Christmas, arrived at the house exactly 48 hours later. Decades of isolation at a parent's bedside create a specific kind of exhaustion. You become so focused on managing the daily survival of someone else that you rarely prepare for the cold, transactional reality that begins the moment they are gone. On paper, the estate was straightforward. A 2011 will divided the mother's house and her $94,000 in savings straight down the middle, equal shares for both daughters. But Linda didn't arrive alone. She brought an attorney named Gerald. And on Friday evening, Gerald sat at the kitchen table and handed Margaret a new document. He called it a standard estate administration agreement. In reality, it contained a clause designed to waive Margaret's right to claim any compensation from the estate for the 19 years of care she had provided. Margaret picked up a pen, but instinct made her hesitate. She put the pen down and said she wanted her own attorney to review it first. Gerald and Linda looked at her, and they both smiled. The sharpest hazard for a lifelong caregiver is rarely the physical toll of the work itself. It is the sudden, highly prepared legal maneuvering of an absentee relative stepping in to protect their half of an inheritance. The next morning, Margaret called Patricia Fontenot. Patricia had spent 28 years practicing estate law in Baton Rouge, and she immediately told Margaret not to sign a thing. This diagram illustrates the central legal principle Patricia introduced, quantum meruit, which translates to as much as deserved. This law allows someone who provided significant caregiving to an elderly parent to claim compensation directly from the estate. It forces the value of those services to be paid out before any assets are split between the heirs. However, the law doesn't simply take your word for it. This claim is not automatic. To secure the value in that care, you must have a physical, meticulously detailed paper trail that bridges the gap between a daughter's memory and a court's requirements. Estate law does not recognize exhaustion or emotional weight. For a caregiver's sacrifice to hold any weight in a legal dispute, it has to be quantified into hard data. Margaret had exactly that. In her spare bedroom, she kept a cardboard box filled with 19 years of wall calendars. Looking at these calendars, we see the sheer volume of data Patricia extracted. Margaret had documented 1,247 attended medical appointments. Below that, she cross-referenced pharmacy records to prove over 6,890 days of managing 11 different prescriptions. And finally, she verified 4 separate extended overnight hospital stays. Patricia's firm compiled this raw data into a massive 41-page legal filing and submitted the claim directly against the estate. An everyday habit of circling dates and making notes had morphed from a quiet coping mechanism into 41 pages of undeniable leverage. Gerald immediately called to dismiss the filing as excessive. Then Linda called Margaret directly. She told her sister that she was being adversarial, that their mother wouldn't have wanted this, and that ultimately they were family. Margaret listened quietly. But instead of engaging with the guilt, she replied that her attorney would handle everything from here and hung up the phone. 4 months later, facing an insurmountable wall of evidence, Linda's attorney advised his client to settle. Margaret received her equal 50, but keeping a meticulous record of those years ensures that someone who chose to stay away cannot legally pretend your sacrifice never happened.